All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Citizens versus the State of Florida versus Florida Public Service Commission, number 2023-0988.
Good morning, and may it please the court, my name is Allie Westling. Here on behalf of the Florida Office of Public Health. I have the privilege of representing the approximately 116,000 customers of the city gas, and I would like to reserve 5 minutes of my time. And while I'm happy to answer any questions regarding the acquisition adjustment issue in this case, I would like to focus my time on reserve surplus amortization mechanism, or the RSAM, as well as the RSAM depreciation. We are here today because the Commission has failed to apply its own rule as well as its well-established policy and prior agency depreciation practice, which is a violation of Section 12068 and a departure from the essential requirements of law. I would like to urge the court not to get too bogged down or distracted by the technical accounting issues that are in this case. The legal issue here is relatively straightforward. This is a rate case, and in every rate case, depreciation is an essential component.
So I understand, I mean, as someone who's trying to understand this, I get that the accounting stuff, I mean, especially for a lay person, it can be confusing, but can you just explain to us how this relates to the rates that the customers would actually be paying? Because I know one of the issues is if there's going to be savings or whatever, but it seems like this really has more to do with timing of when people pay and who pays. And so I think it would help us understand what's at stake if you could just kind of explain how these calculations translate into what people actually pay.
I'll do my best. I'm not an accountant either. The way I would explain it is that anytime a company requests a rate increase, ask for, they state what the revenue requirement is for what's necessary to provide the service that they need to provide to customers. And there's an equation, essentially, I'm going to get the gist of it right, but essentially you look at the income, so the revenues that are generated by customers, and then you subtract what the expenses are that the company has to provide their service. And then you look at what the rate base is. Now the rate base is plant, that's the infrastructure. In this case, a gas case, it's the mains, it's the pipes, it's the meters. All of the infrastructure of the company is a component of rate base. And there's a term known as the return on equity, the ROE, that's also, as I'm sure the court's aware, a common factor in this equation. And essentially, the ROE is multiplied by the product of those, the income and expenses and the rate base, and that's how that revenue requirement is determined. So essentially, in this case, the depreciation is an expense. So the it is a component of the expenses of the company to provide service to the customers. So it's one of those things where you take the revenues of the company and you take all of the expenses, one of which is depreciation, and then that's how that applies to the rates. More broadly, the depreciation, the goal of depreciation, which is undisputed, this is in multiple commission orders. I doubt that counsel would dispute that the goal of depreciation is to match the cost of the consumption of the assets with the service life of the assets, so that customers who are currently paying rates are not paying more or less than they should for those assets at the time that they are receiving service. So assets could last 50 years, but a customer might only live in Florida for 20 years. And so you just want to make sure that for the amount of time that they are getting the benefit of those assets, they are paying the accurate depreciation expense. And that is, again, the goal of depreciation, and that is called the matching principle, actually. It's a principle used nationwide, if not worldwide, in order to determine what depreciation is and what the depreciation expense should be. And in Florida, the way this matching principle is achieved is by following the Commission's depreciation rule, 25-7.045. And in a settlement agreement situation, depreciation issues are stipulated. So the depreciation rule is not.
Do you think the rule on its face makes it impossible or outlaws the creation of a reserve imbalance?
That is certainly our position, and I'm happy.
Where textually do you hang your hat?
So there are three different reasons. There's a conceptually, there's a textually, and there's a commission practice that demonstrates this. But to answer your question about textually, if you look in subsection 1 of the depreciation rule, that's where terms like reserve, reserve surplus, reserve deficiency, that's where those terms are defined. And then subsections 4A and 4C require every gas company to file a depreciation study at least once every 5 years or any time they're requesting a rate increase. And so that right there shows you the fact that
How is that a prohibition on the creation of an imbalance?
It's the totality of the rule. That's one section that demonstrates just this.
I guess what I'm getting at is you're using a word like accuracy to describe depreciation. And the trouble with that is, equipment can outlive its estimated useful life. And so inherent in the concept of depreciation is the idea that it may be adjusted. And we're behaving like, it's depreciation is this like rule of science. It's not, right? Accounting principles operate by general consensus. And if there is, in the Commission's view, sort of a consensus reason to extend the useful life of a chattel and to depreciate it differently, I don't see why that would be outside their regulatory authority to make that determination about what would constitute an appropriate depreciation schedule.
So I absolutely agree that depreciation is something that can change. Pipes, can be in the ground.
Surprise, yeah,
right,
it actually made it.
There's a new study. This plastic pipe can last 20 years instead of 10 years. And that's why this study is required to be done. It's a recalibration, if that's a different word that might explain the concept. But because these studies are required to be done on a schedule and anytime rates are expected to be increased, that is taking a snapshot, looking at the state of the assets at that point in time, and using and setting depreciation parameters that will make sure that the matching is accomplished. The depreciation rule, the concept of a surplus is a byproduct of the depreciation parameters. It's the parameters that the Commission approves.
Is it your position that if the Commission could fix no surplus, that would not be arbitrary? It's
the Commission's policy and precedent that any imbalance, whether it's a surplus or a deficit, must be corrected, and as quickly as possible. And going back to your question about the rule and the text of the rule, subsection 5, subsection 4E says the Commission must investigate the possibility of corrective reserve transfers before changing depreciation rates. And subsection 5F, which is where, in subsection 5, that's where it lists what must be included in the depreciation study. And one of the essential things that must be included in the study is an explanation of the justification for the parameters that the study suggests. And that explanation and justification must—
An explanation and justification for each such category of depreciable plant defining the specific factors that justify the life and salvage components and rates being proposed?
Yes, yes, Your Honor. And then
I understand. Isn't your argument? I mean, in this case, the Commission was presented with 3 ways of calculating the rates, right? There was the year rate, there was the most reasonable one that the company put forward, and then there was the RSAM adjusted rate. Okay, and my understanding is that this would be a different case if the question was, okay, which one of these is the most accurate kind of assessment of what the depreciation is? And the commission says, well, you know, this isn't a science we're predicting, but we're going to pick option C because it's the best way of calculating depreciation. It seems like here, the reasons that the commission gave for choosing the one that it did have nothing to do with what's the most accurate way of calculating depreciation. It's how can we have this, and this is where the accounting comes in, because I don't understand exactly what the significance of it is and what the money can be used for, but it sounds like, hey, we want this extra 25 million, I know it's 50, but the amount that they're asking to use is the 25 million. We want this extra 25 million there to use to, you know, make sure that we're hitting our ROE and, you know, interest, inflation, whatever. That just doesn't seem like, that seems like a completely different kind of consideration, that if the company wants this extra money in there as some sort of operating cushion, I can understand why a regulatory regime would allow them to do that, but it just doesn't seem like that's what this particular calculation is supposed to be about.
Yes,
I mean,
Your
is
Honor.
that your point?
Yes, Your Honor. Our position is that this depreciation rule is essentially a recipe for calculating depreciation, and this rule approves parameters. And to just put a finer clarification on one thing you said, Your Honor, there were 3 sets of parameters proposed in this case. There was the set of parameters that was the result of the 2022 depreciation study conducted by an expert witness retained by Florida City Gas. Those parameters would have resulted in a $3.2 million deficit, which is really relatively, it's very close to zero. That's very close to that matching principle being achieved. Our witness and looked at that depreciation study, which is company specific. These are FCG's assets, and he looked at that study, and he suggested adjustments to certain service lives for certain categories of pipes or things like that. And those adjustments would have resulted in approximately a $2.5 million deficit. So really only about $700 or $700,000 difference between FCG's expert witnesses parameters and our witness. And then on the complete opposite end of the spectrum, the company acknowledged that they said, here are the parameters that are consistent with the rule. We did our study, here's our parameters. However, here are these alternative depreciation parameters that we want an RSAM, and in order to have an RSAM, we have to have large surplus. And they suggested reverse engineering depreciation parameters, which goes against the rule, and to create that surplus. And so there's a $3.2 million deficit, which is consistent, which is the result of the company's specific study. There are adjustments, which is a $2.5 million deficit, and then there's a $52 million surplus from these admittedly alternative, meaning alternative to the depreciation study parameters, rates that you could approve, Commission, that will allow us to do all of these things.
Can you explain, though, and that's where it gets confusing to me, is what is the consequence of that surplus being there? Like, what does that mean in practical terms?
It is artificial, and it is created. There are more subsections of the rule that I can point to where it talks about the need to correct deficiencies and surpluses and Commission precedent, but essentially, just looking at 5F, it talks about there must be a discussion of the proposed reserve transfers between accounts intended to correct surplus reserve balances. This rule, which is, again, the matching principle, it is about correcting surpluses.
But can you just explain, forget the rule for a second. The company has this surplus. What are they allowed to do with it?
They are allowed to do anything they want at any time, and it is not necessarily corrective at all. It is entirely possible that that surplus will remain, well, at least $27 million of it is sitting on a shelf, unchecked, unchanged, unaddressed.
How does it affect the base rate?
The base rate, it affects the depreciation expense. So it affects the category of expense that goes into that rate equation. So if expenses are higher, then the rates are going to be higher. If expenses are lower, the rates are going to be lower. On record page 194, this is an exhibit that was attached to one of the FCG witnesses' testimonies. It's sort of a summary of the RSAM. And this shows you that especially in subsection 3D, it talks about how FCG may record credits to depreciation expense and debits to depreciation reserve, or the opposite, debits to depreciation expense and credits to depreciation reserve. That's that two-way street, meaning they can go back up to 25 million, or they can come down from 25 million. There is nothing that is guaranteed to be corrective, and it says at any period and at FCG's sole discretion. Normally depreciation rates cannot be changed without commission approval. The RCM
can I
gives
ask you a question?
the
Because
company.
when I look at the final order, it seems to be considering depreciation in the context of rate making holistically. If we use this, then there's a reduction of revenue requirement, we save customers money, et cetera. And it seems like your argument is that your reading of the depreciation rule means that the commission can exclusively consider this method in a corrective posture only. Is that your argument?
Essentially,
or do you think there's a broader consideration that the commission can make of depreciation and creating a surplus, et cetera?
When it comes to a fully litigated rate case, which this is, there was no settlement agreement here.
Which that's another issue, but
Yes,
that's a
first,
rabbit hole,
yes.
but go ahead.
Yes. To try to answer your question, though, in a fully litigated rate case, the commission must follow its depreciation rule. And the depreciation rule requires these studies and these proposed parameters to be presented, and that in the event—
Isn't your argument broader, though? It's not that it requires it, it's that it precludes consideration in this context, right? I mean, that's what we would have to essentially determine from the language of the rule.
Yes, and I would add that there is no rule or statute that authorizes an RSAM. The only rule or statute that relates to depreciation in the rate-making context is this rule. And this rule, when it talks about imbalances, it only talks about correcting them. It does not talk about the word correct appears 3 times in this rule. The word create does not appear once. This rule is about achieving the matching principle, and it's a fairness principle that making sure that the customers who have the benefit of the assets only pay what they should. They don't pay more and they don't pay less. And in a litigated rate case like this one, the commission must follow the rule.
Well, yes, but I mean, your argument presupposes that there is a right answer. Your argument presupposes that there is no judgment to be exercised about what the depreciation ought to be, and the rule doesn't seem to match up with it. The rule, all it requires is an explanation and a justification as part of the depreciation study. If I read 5F, I think just at its words, I don't know that 5F is consistent with a world where there's only one correct depreciation rate.
And Your Honor, there's a case
There's play in the joints, right? Otherwise, there'd be nothing to explain.
There's a case that I think would perhaps help with understanding how the commission has historically interpreted this rule, and that it is. So
yeah, let's talk about that. What constitutes a practice? How consistently does something have to, adhere for it to be a practice that should override the requirement of the rule that there be some play in the joints?
Your Honor, the case I was referring to, it's a commission order. It's 2010-0153 FOF-EI. And that case on page 87 says, and that this was an electric rate case, so it dealt with the electric depreciation rule, but they're essentially identical. That case on page 87 says, we find the remaining reserve surplus amount of $894.6 million should be amortized over a 4-year period. This is consistent with our policy. They state what their policy is in this case. And they say— It doesn't say it's dictated by the policy, though. It's consistent with it. There could arguably be other approaches that would be consistent with that policy, right? Not as applied, not as what happened here. In a hypothetical situation, sure, but applying this case, no, Your Honor. This is consistent with our policy with respect to reserve imbalances, which has been to correct them as soon as possible. It is crystal clear that the Commission's policy of interpreting the depreciation issue, which is similar to the way it's done everywhere else, is that when there is an imbalance, whether it's a surplus or a deficit, our policy is to correct that imbalance as quickly as possible. I see that I'm running low on time here, so I'll reserve.
Go ahead.
Okay. Did you want to address the settlement agreement issue, Your Honor?
No.
Okay. All right.
Only just to say that it's the idea that, the whole thing with the settlement agreement, the idea that that can in any way excuse things that are outside of the commission's authority, just because maybe doing one thing that's off here kind of offsets some other benefit somewhere else. I mean, that's just sort of a problem with this whole area that at some point we're going to have to straighten it out, because it makes no sense.
Mr. Honor, I'll reserve the rest of my time.
Good morning, and may it please the court. My name is John Rubottom, and I represent the Florida Public Service Commission. The court should affirm the commission's orders because its decision to approve the RSAM and RSAM adjusted depreciation parameters, as well as its decision to continue amortization of the acquisition adjustment, are consistent with the commission's rules and its officially stated policy and practice, and because the commission's findings are supported by competent substantial evidence.
The other side in their brief said that this had never been done in this method before outside of a settlement. Do you agree with that this is an anomaly, or the first time that you guys have used the depreciation in this way?
No, Your Honor, I don't agree with that. In this case, the commission acted consistently with its practice by addressing the commission's request for a particular set of depreciation parameters and addressed and assessed the evidence supporting it, whether it was reasonable for that utility's assets under the circumstances.
And so it's consistent that in an actual hearing, this type of surplus has been approved, which seems to create a surplus versus correct. That's consistent with your policy. Certainly,
and we take issue with our friends on the other side, how they frame the creation correction issue. Again, even one of the cases they cited from an electric utility case approved a massive surplus of over $1 billion. And that was a result of the approval of depreciation parameters proposed by the utility that the commission found were reasonable under the circumstances.
But isn't the anomaly here, though, that the company went through the whole study that was based on their particular assets, interviewing the people there, et cetera, it was individualized, and the witness said this is the most reasonable, and then the company said, oh, by the way, if we use this methodology that was developed by another company and apply those parameters to our assets, then we, lo and behold, we have this $50 million surplus, which would be nice to make the RSAM work and blah, blah, blah. So it's not so much the amount of the surplus necessarily, it's the means that were used to get to it and the reason for choosing this. It seems. So answer the anomaly question first. Is this an anomaly in the sense of instead of using the company's specific analysis, just taking off the rack an analysis that was developed by another company and then applying it to theirs?
We don't agree that that's an anomaly. We would say that that's a matter of degree. Inherent in depreciation study itself is the assessment of this type of asset across a broad range of other utilities. How are they situated? What kind of assets do they have? How are these types of assets performing? How long are they lasting? The comparison to other types of utilities is inherent. In the commission's clarifying order, we cite to another case, the approval of depreciation parameters that came from a proxy group, a small group, a proxy group comparing Florida-specific utilities. In this case, the commission looked at one particular utility's depreciation parameters and judged those parameters to be reasonable. And even the utility's expert witness, Alice, even though he testified the 2022 study parameters were most reasonable in his opinion, he also testified that the RSAM depreciation parameters were reasonable for FCG's assets. And FCG had two other expert witnesses that testified to the same effect, that they were reasonable for FCG's assets. It's not that they were...
It seems, and I apologize for interrupting you,
certainly.
There's an element of this whole thing of kind of the tail wagging the dog, in the sense that the reason that's given for choosing this is if we don't do it this way, then the RSAM won't work. But it seems like you would think that you would come up with whatever your best guess as to the depreciation is and then say, okay, well, given that, how do we then come up with a way to sort of deal with, this potential imbalance? I mean, it's kind of weird to say that we've got to choose this because this solution that we came up with, or our desire to have this pot of $25 million there won't work unless we use the, I mean, it seems completely reverse engineered. Why is that wrong? Why is that description wrong?
It's wrong because again, we're talking about the reasonableness of the Commission's judgments in what's reasonable for this utility. And the Commission addressed the petition of the utility that came in with a comprehensive 4-year plan. And so again, the Commission looks at the rates holistically. And so when the utility comes in and says, this is a set of depreciation parameters we are requesting that is reasonable for our assets, and it also facilitates the 4-year plan that we have that will keep rates stable, that will keep rates lower relative to the other proposals that were put forward, including by our friends on the other side. The depreciation parameters that were proposed resulted in lower rates relative to those. And so it wasn't that the Commission was reverse engineering. The Commission was addressing the petition that came before it, as it always does, but it addressed first the depreciation parameters, saw that they were reasonable. The expert witness testimony supported them as reasonable for this utility's assets under the circumstances, and then addressed what to do with the surplus using the RSAM. Certainly those questions are intermixed because the Commission looks at things holistically, what to do. And the depreciation, the two sides of depreciation, what's a reasonable rate at which we should allow the utility to recover the original cost of these assets. That's what's being determined. To go to your question about how it relates to the utility's rates, customer rates, it's a recovery schedule. How quickly should we allow the utility to recover its investment that it's already made in these assets? And the way that the Commission does that is by addressing and looking at how quickly the plant is consumed, the useful life, and allowing the utility to collect it.
Can I try to boil down? Are you saying then that, just returning to section 120.68, are you saying then that the decision is not a deviation from officially stated agency policy or prior agency practice, or that if it is a deviation, it is in fact explained by the agency as required by the statute? Which of those two is your argument? Our
argument is that it is not a deviation from Commission's policy or practice.
Okay. Then what do you make of the record site? I believe she said it was at page 184 that your friend pointed us to a minute ago about a statement about the policy of sort of eliminating reserve imbalances. How do you square that circle?
First, that is in the context of what to do when there is an imbalance, when there is a surplus. So that's
well, we have that here, right?
Certainly, we do. Absolutely.
Okay, so tick that box. Now what?
Now we look at what to do with it. One of the ways the Commission has addressed imbalances, surpluses, is using the remaining life technique, which even our friends on the other side were advocating in the case below.
When have you used that before?
That was used again. That same electric utility, well, we cite to some examples of that in our brief. I can't think of one off the top of my head, but we cite to several examples where the remaining life technique is used. But in this case, the RSAM is actually one that the Commission judges will return that surplus more quickly than the remaining life. Instead of adjusting the rates and allowing that to self-correct over the life of the asset, instead we take, the RSAM proposes to take half of that surplus and return it at a faster rate. And there are other instances as well that we cite in our brief where an accelerated method of correcting the reserve imbalance is used. And so it's actually more consistent with that same policy and practice to correct it in a shorter amount of time rather than the remaining life technique.
And just in very layperson terms again, when those have been used to correct in the past, are those correcting imbalances that naturally occurred based on just unexpected things, the pipes, things like that? Are those correcting imbalances that you've actually created, the Commission created?
Well, again, we would argue that even in this case, it's a natural occurrence of depreciation parameters that the commission found to be reasonable based on expert witness testimony. And so, if it's based on witness testimony, on competent, substantial record evidence that these are reasonable, then the question becomes what to do with the surplus. The surplus, an imbalance in the depreciation reserve, is the result of updated parameters that say, in essence, that had these same parameters been applied from the beginning of the asset's life, how would we be doing now? Where would we be on the schedule to recover that original cost? And so again, we take issue with our friend's characterization of the creation out of whole cloth with nothing backing it. The commission found these RSAM adjusted depreciation parameters to be reasonable for this utility under the circumstances, and applied those parameters to the utility's assets and to set their rates.
Can you one thing, and I honestly don't know what the best way to deal with this is, but one thing that kind of, I hate when people say it concerns them, but one thing that concerns me about these cases in general is I read this staff report here that's very logical. I mean, and I'm not an expert obviously on the accounting, so I'm just trying to make the best sense of it that I can. But you go through this thing. It makes sense. It's intuitive. It says, it talks about the parties' arguments, and then it goes through and analyzes and gives reasons for why they think what they do. They go through chapter and verse here about, according to the staff, this is a departure from what you guys do. It's against the matching principle. It's against the idea of, intergenerational equity or whatever the phrase is. It says that it's not going to save people money. And then I look at this order, and it's 2 pages of reciting, party A said this, party B said that, and then these, conclusory assertions at the end of, based on party A saying this and party B saying that, we think that the most reasonable thing is to choose the RSAM thing. I mean, if part of this whole process is to give some rationality to the decisions and a public forum and give the legislature and the public the ability to evaluate what's going on. I mean, what are we supposed to do when the work product is just so consistently inadequate? I mean, I'm not saying, trust me, you guys are the PSC was put there to make the decisions. I'm not implying or saying that the staff should be running the show, but I do think it's weird to have a body that's charged with making the decisions and is given this very thorough, thoughtful, analytically robust report, and then responds to it with just basically like a wave of the hand. It's complete ipse dixit at the end. So what are we supposed to do with that?
Well, Your Honor, I would note that the commission staff's role in this, as I'm sure the court is aware, is we would analogize it to that of a law clerk that summarizes the testimony below, summarizes the evidence, and offers an analysis, offers a recommended decision based on their opinion on the weight of the evidence. They're not the decision maker. It's the commission that weighs the evidence. They're the finder of fact, and they're tasked to make those decisions. Now, I would also note that, and I see I'm running short on time, but I would also note that this order came out prior to the Fair case, and the commission has heard and respectfully understood.
So would you concede that if we applied the Fair standards to this order that it wouldn't meet it?
I don't concede that. I think it is sufficient based on the evidence, based on the issues that are presented. These are findings of fact and judgments of what's reasonable. And the commission, by making the decision it did, it's not required.
So whether something is reasonable, you think that that's a finding of fact. And so basically if that's true, then the utility can come in and have anyone assert anything that they want, and the OPC is going to say whatever they say, and then the commission can just say, oh, look, there's evidence that someone came in and testified that X, Y, or Z was reasonable. That's a quote-unquote finding of fact. There's competent, substantial evidence by them merely saying it, and we're supposed to rubber stamp that. I mean, is that, and I'm not, and it's potentially that's the way cases have gone in the past. But I mean, is that what you're saying? Is that the way this is supposed to work?
I wouldn't agree with the characterization, respectfully, Your Honor. I think the legislature gave the commission broad discretion to make decisions in areas that as we described in our brief, these are quintessentially the type of complex rate-making decisions the legislature gave the commission to make.
You have great authority. The commission has great authority. It just has to say because more than it does. Like, is it so hard to just state the conclusion and then say this is so because? And I don't think that's too much to ask.
Certainly, Your Honor, and I would respectfully submit that this order, in the context of the disputes below, the issues below, the Commission's decision is clear enough to satisfy the requirements of law. And again, to the extent the court continues to express it's that it would like to see more from our orders. The commission is taking that into account. Again, this order was issued prior to FAIR, and it might look different post that FAIR decision. But in this case, our position is the order is sufficient to meet the requirements of law. It sufficiently explains the commission's decision in the context of the issues that were presented. I see I'm well past my time, so I would respectfully ask that the court affirm the orders.
Okay,
thank you.
We appreciate it.
Good morning, Mr. Chief Justice, may it please the court. My name's Lauren Purdy. I'm with the Gunster Law Firm, and I'm arguing on behalf of Florida City Gas. Based on the interchanges between the bench and OPC's counsel and the Commission's counsel, I want to first address some points that have been raised repeatedly. I think I am also not an accountant, so I have been trying to get accountants to explain to me a little bit more about how these concepts work, because I think it's very important for understanding what's really going on here. So, how does depreciation work into a customer rate? Essentially, if you buy a widget, the utility buys a widget for $100. Built into its base rate is recovery of the $100 in the form of depreciation expense. So, whether you recover it in 5 years or 50 years based on how long the asset lasts, you still only recover $100 under the customer's rates. So if in January 1st, 2000, the widget's supposed to last 10 years and it's $100, you start out recovering at a rate of $10 a year. 5 years in, it's an imperfect process. To your point, Justice Carrillo, you realize actually it's going to last 20 years. Well, now you've over-collected. And that over-collection needs to be accounted for going forward, because you've collected $5 more a year than now our updated depreciation rates suggest you should have collected. But at the end of the day, you only collect 100. The RSAM adjusted depreciation parameters here are just saying that Florida City Gas has over-collected based on the assets that it has. That's all it's saying. It's not saying it gets more money. It's not saying it gets less money. It's saying in a surplus, you have over-collected. That's all that it means. So then the question is really two parts. One, was the Commission's decision, its exercise of its expertise, the deference afforded to it, is there competent, substantial evidence in the record for the menu of choices it was given and the one that it selected? Because it is an imperfect process. I'm 38 years old. In North Florida, it may be that the average age of a white woman in North Florida is 80 years old. And I come in and someone looks at my demographics and they say, Lauren Purdy, you will make it to 80, congratulations. And then 10 years from now, they say, congratulations, actually, you'll make it to 90. And then I come back and I'm 58 and they say, bad news.
I'm sorry to interrupt you, but so, because I understand what you're saying, because that's the question is then, though, so the surplus is there, and I understand part of this is that it's just an accounting entry, right? Mm-hmm. So the surplus is there, meaning that the calculations show that more has been collected than if you had had a crystal ball, or if you had used the same numbers, you would have collected less. So now it's there.
Yes.
52 million. The company I guess 27 million. The company hasn't really said what they want to do with that. There's the 25 million there. So explain to me the difference between, in the practical real world, what is the difference for the company between having access to that 25 million versus if they had used the depreciation rate that the expert said was the quote unquote most reasonable one?
So not to quibble with you, Chief Justice Muniz, but two of Florida City Gas's experts agreed that the most reasonable rate, the rate that should be used.
Okay, the one who did the study.
Yes.
He said that it was the most reasonable. I know it would only last for the 1 year, but.
Yes, and he also said that the RSAM adjusted depreciation parameters were also within the range of reasonableness. It's actually only a few years.
Okay, go
Yes.
ahead.
So what does that mean? Selecting among a range of
tell me about what happens to the 25 million surplus. What difference does it make?
What it allows the utility to do is to apply on a credit and debit basis 25 million of that 52 million. It's amortized over just the next 4 years instead of the remaining life of the assets, to pay for and account for other fluctuations, raising higher interest rates, inflation, so that the company is able to basically return that surplus more quickly to customers in the form of a guaranteed general rate that is stable until it has to come back before the commission again. So it's still being returned to customers. It's being returned to customers in the form of a rate that is stable. So part of what the commission was doing in selecting the RSAM adjusted depreciation parameters is saying we can return the surplus and keep the rates hopefully the same for 4 years instead of 1 year, and we have to come back, spend $2 million on another rate case, and possibly do this whole thing again, where rates might go up.
But it's a risk thing too, right? I mean, because they're saying that you can also use the money to make sure that you're hitting your median ROE, right? So in that sense, it's not necessarily, and I understand, I mean, this is it's not a zero-sum game. We want the companies to be healthy and provide good service and whatever, but it seems like it's also creating this padding there to make sure that the company isn't bearing the risk of this stuff. And whereas if you came in and asked for a rate increase, then the commission would have a chance to kind of look at all the variables and decide whether you're entitled to it or not, as opposed to just having this 25 million sitting there that you can use to make up for that. I mean, is that right?
Not exactly. So I think there's a couple points that go to this, right? So one, we have to remember, if the utility falls below the authorized ROE, it gets to come and ask for a rate increase because it's not able to charge reasonable rates. So allowing the company to have the 25 million to keep within the authorized range, part of that is so that it doesn't have to come back.
But it's not just falling beneath the low point, it's also making sure that you're keeping up to the midpoint too, right?
Well, that's ideal, although the record shows and the witnesses that Florida City Gas put on before the commission also conceded that they would use the 25 million, but they would still have to have increased operational efficiencies to even get to the midpoint that they were requesting. I also think it's important to remember that witness Campbell testified before the commission that part of the parameters of this is that the 25 million can't allow them to go above the ROE, and they have to exhaust every single nickel of that 25 million, fall below the ROE before they can request a rate increase. So it's just a mechanism that's part of allowing them to not come back, and they are returning, as the commission's counsel said, the surplus to customers at a quicker rate over the 4 years.
I guess the problem is, to a layman, what's so confusing about this is that it seems like the point of this exercise should be to sort of hit the right target, as opposed to what and I understand it's not, you don't have a crystal ball. So if someone was saying, hey, we chose option C because we think on balance, this is just the best judgment as to the correct depreciation rate, right? But it seems like the reason that's being given is we have all these other variables that are going to affect sort of the cost of doing business and everything, and it would be great to have this $25 million as a cushion for these other things that have nothing to do with depreciation, and therefore that's why we're choosing that option. And so it just seems like it just doesn't compute as to why that is an appropriate reason to choose the depreciation rate, as opposed to saying, we think this is the best depreciation rate, it may result in this surplus, and if it does, this is how we would choose to use it, as opposed to using the surplus itself as the very reason for choosing it. That's a question, honestly, because I'm trying to figure this out.
I think there's a couple different answers to that question. So one, we have to start with what's step one. What is reasonable among the options? There's competent substantial evidence the option chosen was within the range of reasonableness. All three of Florida City Gas's witnesses testified it was within the range of reasonableness. In the court,
is there precedent for it?
Sorry?
Is there precedent for it?
There are approved settlement agreements over and over again, but we would concede that in a contested rate case, that issue has not yet come before this court. The closest has been footnote 2 of the Floridians against rate increase case, where this court acknowledged that the idea that there wasn't statutory authority to approve an RSAM generally was not an argument that would be a basis for reversal. The Commission's order at page 20,937 of the record analyzes why it selected the option that it did, acknowledges—
I think that's a generous use of the word analyze, but go ahead.
And selected the option that it did, acknowledged that there was evidence in the record that it was a reasonable option. It doesn't say we're selecting this option because it reverse engineers a way to have a 4-year possibility for keeping the rates the same.
Does it even say we've selected this option because something?
It states that it acknowledges that Florida City Gas's witnesses testified in a way that they found credible that the RSAM adjusted parameters were reasonable. I also think there's two other points that are important here. One, the use of Peoples Gas's parameters and applying those to the actual assets of Florida City Gas, as Commission's counsel pointed out, is something that has been done before, has been approved before in other instances. So, and witness Campbell testified to the Commission that Peoples Gas was an appropriate barometer, and their parameters were an appropriate method to determine the depreciation of Florida City Gas's assets because it's a comparable utility, same part of the state.
Tell me, just in terms of looking at their order, the Commission had, let's put the OPC approach to the side. They had the they had the RSAM. What would you say is the reason why they chose the RSAM? Let's stipulate that there was testimony that they're both within the range of reasonableness. So obviously, I can't say, well, one of them was unreasonable. They're both reasonable. So why do I choose the one that I chose if I'm the PSC?
Yes, because overall, overarching the entire concept of setting base rates, the 98 pages that is here that the Commission issued generally on all of the things that get baked into rates is the Commission's charge for fair, just, and reasonable rates. And ultimately, the Commission, in selecting among two options that they both found to be reasonable, exercised its expertise and discretion in that overarching charge under Chapter 366 to pick the option that allows it to have fair, just, and reasonable rates. In this instance, a rate that allows for what we hope to be 4 years without a rate increase.
And that's what makes the judicial review difficult, because it seems like you're not really justifying the specific choice. There's all kinds of, let's say there's 100 inputs that go into that. And if we isolate any one thing, and this is where the whole settlement agreement thing becomes a problem. So if we isolate this one thing, you're not really giving a reason. You're not saying that if we had chosen the option A, then the overall rates would have been blah, 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 and those aren't as good as these. It's kind of like you're just asking us to take it on faith that even though we can't really explain why we're choosing option B other than just this kind of cosmic, oh, all the rates are fair? I mean, how are we supposed to evaluate that? Just because someone from the company said it's quote unquote reasonable? I mean, because that's basically, at the end of the day, that's the only thing that's supporting this, is that in the record I can point to a human being that spoke the word reasonable and attached it to this thing. And that's quote unquote competent substantial evidence. And we're supposed to say, okay, great, we're done.
Well, Chief Justice Means, I think this is somewhat comparable to, in a trial court, taking expert witness testimony and an expert provides their opinion and the fact finder might be.
Which is, in a jury case, it's a black box, right? The PSC is a black box. That is my problem with these cases. It's a black box. And the administrative procedure is not supposed to be, it's supposed to be the opposite of a black box. That's the only justification for this whole mousetrap, is to have reasoned explanations for fact-based decisions. And instead we get a regurgitation of the evidence and then like, oh, because so-and-so said this, we think that this is appropriate. We're done. That is literally every order that we see from the PSC.
Chief Justice Muniz, in this instance, in this circumstance, we believe that the Commission's order appropriately analyzes, meets the appropriate standard even under the most recent FAIR case, and does a sufficient job. And this court's deferential standard to the Commission's expertise on what it believes will allow it to set fair, just, and reasonable rates should be affirmed in this circumstance. There's expert testimony finding that the RSAM adjusted depreciation parameters are appropriate. Those parameters, by the way, that were used from the People's Gas case were parameters that were agreed to. So everyone agreed that those parameters for a utility, that the unrefuted evidence is similar to Florida City Gas, similar part of the country, it's a gas utility, very, very similar assets, applied that and obtained a $52 million surplus. All that means is that the utility is saying we have collected back our $100 widget investment more quickly than we would have otherwise. So that evidence is competent substantial evidence in the record. The order is sufficient even under the FAIR standard, and we believe that should be affirmed by this court. The only other point that I wanted to make sure was clear here that we again refute is this concept that this is a reverse engineered surplus. We believe that there was no creation of an imbalance. This isn't an artificial universe where Florida City Gas has created imbalance that is not there.
But you don't disagree that the reason for choosing this approach is that it gives you access to the money that will then allow the overall rates to be what you think are fair, just, and whatever the statutory test is. That is the reason for choosing this approach.
That we believe and that the Commission agrees is fair, just, and reasonable. Yes, that was of the two options that we were given, that we put forth a one-year plan that would result in another rate case 1 year later, or a 4-year plan that would allow the rates to stay the same. Those were the options that were given to the Commission. In conclusion, we understand that the Commission has an obligation to explain its orders. Those orders have to be supported by competent substantial evidence. The RSAM adjusted depreciation parameters are nothing new. This is something that has gone on for more than 10 years with OPC's agreement, consent, that they promoted fair, just, and reasonable rates. The expert testimony that the Commission credited in this case was that the RSAM adjusted depreciation parameters were within the range of reasonableness, and the fact that it results in a $52 million surplus simply means that the utility is saying they have over-collected on depreciating assets. And we ask this court to affirm the Commission's well-reasoned order.
Thanks, and I appreciate it. And I don't mean, I hope you don't think I'm being rude. It's just, these are bigger fish than just this one case, but.
Thank you again. And Your Honor, just to your point about the issue with the lack of an explanation in the orders, I submit to you that there is no string of words that the Commission could include in an order that would justify with competent and substantial evidence the selection of these RSAM parameters in this case. Now, the witness that was retained by Florida City Gas to conduct the rule-required depreciation study The rates he supported as the most reasonable rates were the rates that resulted in a $3.2 million deficit.
Okay, but they also, so what's your answer? Because, I mean, in some sense, at the end of the day, their argument seems to be, look, there were several options. There's evidence saying that they're all reasonable. Once we're choosing from a reasonable option, then in some ways the RSAM thing becomes kind of a sideshow. It doesn't matter. Maybe that was our motivation for choosing it, but as long as it's reasonable, then, you know, the PSC gets to decide, you know, overall what the rate should be. I mean, what's wrong with that?
Yes, Your Honor. So there is evidence that a witness said that all three parameters are reasonable, but that does not mean that it is competent and substantial evidence. When you look at the grouping of two opposing sides being $700,000 apart on what the reserve deficiency is, that should be indicative to the court that is the appropriate.
But you guys,
dispute
you're not citing it. I mean, you're making an argument that from a layman's perspective, it's intuitively appealing, but you don't have any evidence in the record from your own expert saying this. The gap here is evidence that it's actually outside the range of reasonableness, and here's why. Like, I don't see you telling me that that's in the record either.
Our witness, he presented adjustments that he thought were reasonable. He focused on the rule required study. That's what he focused his attention on, is because that is how depreciation has always been determined in litigated cases. You look at the rule, and he looked at the rule, looked at the study, and he responded to the rule-based information.
But he didn't say that. Is there a point in the record where someone on your side testified that, putting aside how you're going to use the surplus, which I think is a separate issue, that choosing this particular depreciation rate is outside the range of reasonableness?
He didn't address a range of reasonableness. He addressed the commission's.
He addressed what he thinks is most reasonable, right?
Correct.
But that's not the question. The question is, it seems like if you would, I mean, there is discretion to choose. So unless once you're inside the range of reasonableness, then other factors come into play.
Well, and that's what I submit to you, is that this range of reasonableness statement that this witness made is a complete outlier and red herring when it comes to depreciation.
But your job factually was to prove that below, right? I mean, it seems like the range itself raises an eyebrow, right? But your job is to put something on the record that someone other than just a layman's intuition supports that.
So in all matters before the commission, the company has the burden of proof, and they put forth their parameters. And what we did, not having the burden of proof, we don't have to do anything.
Well, but if you want to win, when they have someone that says this is reasonable, then, I mean.
The way I can explain this, Your Honor, is just they have the burden. They have the burden in every element and aspect of a rate case. We, in this case, presented, we looked at what they presented, what their expert said was the most reasonable rates. And our expert provided testimony that adjustments to what were, at the time, the most reasonable rates. And that's what he focused on. And something that is absolutely crucial for this court to see and to recognize about the bigger picture about this case is that the study resulted in a $3.2 million deficit. What these alternative RSAM parameters do is they create the problem and then come in like a white knight and say, here's how we can correct this problem that we've just asked you to create. That is the problem here. It is so important for the court to understand that if the rule and policy and practice and everything.
With what effect on rates?
What effect on rates?
With what effect on rates? So
the company said that this is going to save customers, I think, $10.8 million over 4 years. However, going back to that.
Is that argument without any support in the record?
Yes, Your Honor, and that's what staff said as well. Staff, which consists of a professional group, a team of accountants, attorneys, and engineers, looked at all of this, and they wrote an over 200-page staff recommendation. And they said on page record site 20436, this is a direct quote from the staff recommendation. They said the record does not support FCG's assertion of $10.8 million of savings to customers under the RSAM depreciation parameters. And to the court's point, nowhere in the order does it even address this issue. It just says, we think FCG said it, so I guess that's what's going to happen. The order doesn't say anything, but the staff recommendation, which again is as the court is aware, this is a thorough analysis of all of, you don't have to take my word for it, you don't have to take the company's word for it. This is the neutral staff who looked at all parties' statements and arguments, and they recommended to the commission there is no record support for these savings.
Well, the commission's order, though, doesn't really rely, and this is the beauty of being able to just say because we say so. They're not hanging their hat on any particular savings. They're just saying it'll result in a reduction of revenue requirements, save customers money, and give FCG the ability to manage its day-to-day business fluctuations. So, I mean, in some sense, if you can sort of just wave off the kind of micro issues, then maybe it doesn't matter whether there's evidence for that particular savings or not.
Right, and I would also add that the conclusory statements in that section of the order approving the RSA, they only talk about what FCG said. They do not address anything that was raised by OPC or any of the other interveners in this case, or what their own staff recommended. They just say FCG said this, so we're going to approve it.
Okay,
now,
you can have 30 seconds to wrap up.
Thank you, Your Honor. I would close by saying that the competent substantial evidence is an important thing, but the rule issue is dispositive here. If the court finds that the commission has acted inconsistently with either its rule or its policy and practice without an explanation, then you don't even have to worry about what the order says and how it supports the conclusion. Now, if this court continues to hold that Chapter 120 requires agencies to take actions that are consistent with their rules and policies, then the only proper resolution of this case is that these orders be reversed and remanded for further proceedings which are consistent with the commission's rule, policy, and practices, all of which require the correction, not the creation of reserve imbalances. Thank you.
Thank you very much. We appreciate it. Okay, our next case is Wilson versus State of Florida, 2023-0320.
May it please the court? My name is Catherine Radke, and I represent Mr. Wilson. Mr. Wilson was sentenced to death. I will address a few issues. We stand, however, on all issues raised in the briefs. As to issue number 1, the trial court erred as a matter of law by allowing the jury to consider the cold, calculated, and premeditated aggravating factor under the circumstances of the trial in this case. The written verdict on the murder counts was a general verdict of guilt. That verdict was reached just minutes after the jury had told the court that it had not reached unanimous agreement on the premeditation theory. In many capital cases, a verdict of guilty of first-degree murder is valid whether or not it reflects unanimity about the underlying theory of guilt. But in this case, the state conceded below that if the jurors had checked a box to say they were unanimous only on the felony murder theory, the state would have been precluded from seeking a finding that the CCP factor was present. The state only pursued the EHAC aggravator as to Tayton. There were 2 victims.
Counsel, let
Yes,
me
sir.
ask you about the premise for this whole argument. And maybe I'm missing something here, but it seems like to me that what the jury came with to the court was a concern about the verdict form, and it really presented a hypothetical question. So it says, so if we are not unanimous as to pre-med, which line on the form do we use? Now, there are smart people on juries, and when they look at a form that really doesn't make sense and doesn't, they might very well ask a hypothetical question that would not reflect anything about whether they are unanimous or not unanimous, because it is framed as a hypothetical question. If we are not unanimous, what am I missing about that? Now, I'm not sure that matters really anyway, but it is kind of the premise for your whole argument here. It seems to me to be faulty. So tell me why I'm wrong.
Your Honor, I would say that's not faulty. Well, you are a little faulty, rather, with all respect. I used to do a lot of trials.
I'm usually at risk of being faulty. Counsel agrees right there.
Yes, sir. Well, I've done a lot of trials, and frequently it's my experience the jury comes out and they say, Judge, we have a question, but some of us are thinking along these lines, and that's the way it appears to me in reading the record.
Well, I'm just reading what it says here. I'm just reading what I see in the record. And
Yes,
again, I understand that there are people that will spot a flaw in what has been presented to them and say, why would you give us that? And then kind of come back and say, well, this jury's really smarter than these lawyers who gave us these instructions or who teed these instructions up for the judge.
Or they're saying, and what we believe is more likely, they're saying, Judge, we're not all in agreement. We are not unanimous. What we are asking the court to do is give us a little more guidance there.
How do we decide this issue in favor of your client based on anything other than speculation, though?
I would say it's not speculation, Your Honor. There's some further indications in the record that that he was not unanimous. The disagreement in the trial court concerned the effect of the jury's revelation that it did not unanimously find that he premeditated the killings. The record shows that only 5 minutes elapsed between the pause in the deliberations and the jury verdict. They were previously out for 2 hours. So it's unlikely on this record that the jury changed their minds in just 5 minutes, or that the verdict was based on a unanimous finding that premeditation was shown.
That still seems very speculative. We're kind of imagining what they were doing.
I don't think, well...
Can you direct us to a case where we've relied on time of deliberation as a factor in determining the validity of a jury's conclusion or a verdict?
I'm right offhand, no, Your Honor.
I don't think there is one.
I'm not aware of it.
I find it interesting that you call that part of the record. I suppose technically you're right, because the record will contain the time they left and the time they came back in, but I can't think of a case in any court where that has been a germane consideration along the lines you're proposing here.
Well...
I mean, it kind of follows that it's just as likely if we were speculating that Justice Kennedy's hypothetical was correct and that they were just kind of proposing something, and the minute the form was cleared, they had already agreed on everything, and so it only took 5 minutes to fill out the correct form. I mean, if we're going to speculate, you could kind of go both ways on that.
I don't know that it's speculation, because there are some other factors that were going on in this case with the jury and with the jury instructions that were going on that suggest that there was definitely a problem in the arguments as well with the state trying to direct the jurors. to ignore a lot of things that were being said on behalf of the defendant, or the appellant in this case. If you look, for example, at point number 5, where we're arguing the trial court erred in denying the defense request to amend the standard jury instructions to remove the reasonable qualifier from the definition of mitigating circumstances. In that instance, during the state attorney's closing, and this is part of that argument, if you go to pages 3407 to 3409 of the record, the state's closing argues that if the jury finds any aggravator to be proven, it still has to be unanimous. And when you look at the mitigating circumstances, the argument continues, it can be anything. And then they're sort of poo-pooing the 45 mitigating circumstances that were submitted by the defendants, by the defense. And that goes into another issue with the instruction requiring, according to the state, that anything that reasonably indicates the death penalty is not appropriate could be considered as a mitigator. But then they're arguing about weighing that against the aggravation, the aggravators, that mitigating factor, which, if it exists, does it reasonably indicate the death penalty is not appropriate? And suggesting that one aggravating, in the argument, that one aggravating factor can outweigh any mitigating factor shown by the defense. And that's where the federal constitutional law comes in. The argument by appellant is that the denial of a special jury instruction is reviewed for abuse of discretion. A special instruction must be supported by evidence, but we're asking arguing based on federal law that the standard jury instructions should remove the reasonable qualifier from the definition of mitigating circumstances. Florida, I'm sorry. I thought somebody was starting to say something. Florida's preliminary and final standard jury instructions for use in the penalty phase both include this reasonable or reasonably qualifier. But our argument is that should have no place in the jury room. It requires the court to address aggravating factors and mitigating circumstances that are reasonably established by the evidence. But the U.S. Supreme Court requires in capital cases that each juror must be allowed to consider all mitigating evidence. The state's argument then in closing really cuts against that. And it's our argument it should not. The cases, the chief cases in this area are, and I'm not sure of the pronunciation, but it looks like McCove versus North Carolina, which cites to Mills versus Maryland. The requested charge change to the standard instruction would have effectuated the defendant's right to be protected by federal and Florida due process clauses. That's one of the more important of the issues that we have in this case.
Even if we agree with you, though, don't we have to find that the court abused its discretion by adhering to the standard jury instruction?
Yes, Your Honor.
Okay.
Yeah. That's argued also in the facts of this particular case and how the trial progressed. The requested change to the standard instruction would have effectuated the defendant's right to be protected by the federal and Florida's due process clauses to have his jury correctly and intelligently instructed. the appellant has the right to heightened reliability in the capital process, in the proceedings, and the instruction that was requested would have effectuated his right.
I'm just
Yes, sir.
struggling to understand how it's protecting somebody's right to essentially say you can have unreasonable mitigation. That seems to be what you're suggesting.
Your Honor, I don't think it's unreasonable mitigation.
Well, but you're quibbling with the word reasonable, right?
Well,
what's the opposite of reasonable? The opposite of reasonable, with which you quibble, is unreasonable.
actually, there's no requirement. In fact, the federal case law is certainly.
So now we come to it. You can have unreasonable mitigation. This is about the vaunted constitutional right to have unreasonable mitigation.
I'm sorry, Your Honor, that's not what I meant. What we're saying is there's mitigation. It has a basis in fact. 45 mitigators with bases in fact were being argued against by the state as being things the jury should just disregard. And the jury should only go to it if it's reasonable. And then it goes on to argue that the mitigating factors.
In this arena, isn't it the case that you've got two different things going on with suggested mitigation? You've got whether it is factually established, whether the underlying facts, in fact, obtained. But then you've got the question, even once you get over that hurdle, you've got the question of whether it is of a mitigating nature. And those are kind of two different things. The fact that somebody comes and says that this is mitigation doesn't mean that it's mitigation. I mean, it's not an automatic thing just because they assert that it's mitigation. Am I missing something when I think that?
Well, Your Honor, if you have expert witnesses, as there were in this case, on the appellant's behalf, and the argument of the state is urging the jury, apparently, to just not accept that as part of this reasonable jury instruction, which is not at all in line with what should have been done.
Well, I mean, the problem, to a certain extent, here we have these dueling experts, different views expressed by experts. And the finders of fact are entitled to discredit.
Yes, Your Honor, but I need to add that that was not nearly the only mitigating factor here. There were 45 mitigators raised in this case. And to have an argument allowed to tell the jury, oh, don't mess with any of those, seems unfair, not in line with due process. And I actually did affect adversely my client's rights to be protected by the Due Process Clause, to have his jury correctly and intelligently instructed.
So are you, I just want to make sure I'm clear on the argument, is it that the prosecutor in some sort of argument incorrectly used this in a way that was an error to not have been corrected, or that it was the jury instruction itself?
It's the jury instruction, and this particular argument was sort of allowed by that jury instruction, or at least it apparently encouraged this argument, because the prosecutor was repeatedly using the word reasonably, which it's our view does not belong there at all. The word reasonably detracts from his rights to have a jury intelligently instructed and to have them. There's a little more to the reasonable qualifier that seems to have been incorporated into the standard instructions. It requires, well, it applies to the review of sentence orders, but should have no place in the jury room, is our argument. As it may.
But they were also told that they could look at anything that supports all mitigators and anything that supports life sentence or might indicate that the death penalty. So the words anything, right. All, they're also used there, correct?
Yes, Your Honor, they are. However, this particular argument seems to negate all of that, is telling the jury to just ignore it. Just ignore it.
The argument on behalf of the prosecutor.
Yes.
And was that objected to?
Yes, Your Honor.
That was a preserved, and was that in the brief?
Yes, Your Honor. That's in point 5. That's in both briefs. All right. So let's see. Going to point 3. At this point, the victim impacts testimony should not have included reference to past trauma to the victims' families. You may recall there was some pretty severe things that had happened to 2 children in the family prior to this, and it was that victim impact testimony was allowed over objection, but it was references to past trauma to the victim's family, which had nothing to do with this case.
Well, doesn't it explain the context that the family was going through when they experienced this additional tragedy? I mean, apparently the victims here had just come to be with the family a couple of weeks before, and they'd come because of these earlier tragedies and they decision was made to get the family closer together, and then this horror befalls them. And it's just explaining that context, which intensifies the significance of the loss. It kind of puts the loss associated with these murders and the loss of the lives of the victims in the context that was experienced by the family. Isn't that right?
No, Your Honor. With respect, that's not right. The victim impact testimony should not have included that reference because that evidence was a source of prejudice, had no probative value to this case, and it was not admissible, thus, under Section 90.403. Can
we have a look together then at Florida Statute 921-1418, which talks about what victim impact evidence shall constitute and the nature of its probative value. It says such evidence shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death.
Yes.
You're saying, I struggle to see how that doesn't cover exactly this kind of evidence.
Maybe I wasn't clear. The evidence that we're talking about was not anything to do with the deaths of Tayton and Robert. It has to do with testimony by members of the family concerning a stepdaughter who had been in the ICU the previous year with a severe infection and had died of septic shock. And then another stepdaughter who was in a bad car accident. And that's the prior.
No, but maybe we're talking past each other. I'm talking about Deborah Benson's testimony.
I'm sorry?
Deborah Benson's testimony.
Okay.
About how they only had 2 weeks together with the boys, the circumstances under which they came to be there.
Oh, okay. I'm not referring to that.
Okay.
Okay. That's perfectly acceptable.
So which testimony are you referring to?
Just the stuff about the 2 stepdaughters, primarily. That's the victim impact testimony that should not have been included with reference to past, it should not have included this reference to the past trauma to the family with these stepdaughters that had nothing whatsoever to do with Mr. Wilson. It had nothing to do with these events. that was something that is just, it's a loss that was not caused by anything to do with this case and should not have been included. It was prejudicial.
How is it? Obviously, it's prejudicial. I always used to love it when people would stand up and say, "Objection, prejudicial, hurts me." But that's not the question. The question is, how is it an abuse of discretion? How is it that no reasonable judge could allow that in?
No reasonable judge should allow that in, given the duty of fairness that the judge owes to the appellant, to the defendant in a case. The judge should not, this has nothing to do with the victim's uniqueness as an individual.
I think it does.
The stepdaughters? They're not part of this case.
I think it's very, well, I don't mean to argue with you, but couldn't a reasonable judge conclude, as Justice Kennedy was articulating, that it makes sense to tell the story of how these people all came to be living under this roof and how this tragedy occurred?
We must respectfully disagree then.
Okay.
Yeah.
But underlying your point here is that somehow this is going to cause the jury to have sympathy, inappropriate sympathy for the family here because somebody died in the hospital. That's going to be greater than whatever judgment they might render based on the fact that these two young boys were beaten to death with a hammer and had their necks, their throats slit.
Yes, Your Honor, it's inappropriate. We're arguing there for a new penalty phase because the loss, the evidence that is supposed to be admitted must show the victim's uniqueness as an individual and the loss caused by that victim's death, which isn't related at all to the two stepdaughters and their illness and car accident. While the disputed testimony explained the extent of their loss, it did not tend to demonstrate the victims' uniqueness as individuals. By victims, I mean Robert and Tatum. The impermissible portion of the statement should have been redacted. Okay, let me go back to As to point number 2, the trial court erred in excluding the mitigating evidence from the weighing process by refusing to consider the defense experts. Whether a circumstance is mitigating in nature is subject to de novo review, and this particular argument implicates the findings of Eddings versus Oklahoma. All mitigating evidence must be considered and weighed. And in this case, the court declined to consider the appellant's irrational statements that he made. The two questions before the trial court.
So, I mean, he was saying all kinds of things. There's no question about that. He's trying to deflect, and he's in a bad spot. But in their testimony, expert testimony, that there were signs that he's malingering?
That was from the state's expert, I believe.
Well, yeah, but that's there. I mean, it may be the state's expert, and you may not like it, but that's there.
But the thing is, Your Honor, the court can't exclude mitigating evidence from the weighing process, and it refused to consider the defense experts.
It's very clear that in our case law that a particular story can be I based on the facts that are in the record. And
but Your Honor, that's not the only thing. I disagree actually that it's being discredited. He said some remarkably strange things, and one of his experts was talking about, if I recall correctly, and I don't remember which expert, but one of the defense experts said something to the effect of his brain damage from the lengthy long-term use of meth. If he's got a brain, if his brain is damaged
Well, I
to that
understand
extent,
your position on
then
that,
it's definitely mitigating.
But you will have to concede that there are other things in the record pointing to other ways of looking at what was going on and the impact that the meth had in this particular episode, and these particular two murders to which he confessed.
well, I really don't think I can concede that, Your Honor. Well, I respect your opinion, but this mainly is about making sure that the court does not exclude mitigating evidence from the weighing process. It must be included.
Oh, sorry, you're welcome to keep going, but you're eating into your rebuttal time. It's totally up to you.
Okay. All right. Let me save a couple minutes then.
Okay, thank you.
Good morning. May it please the court, counsel. My name is Doris Meacham, and I am here on behalf of the state. I will start with claim 1, as counsel did, regarding the jury instruction. It seems that the jury was confused because the jury instruction was incorrect, and that was why they came back with the question. As Justice Kennedy noted, and the court did as well, again, the jurors are smarter than all of us. Apparently, the first prong of the verdict form was confusing because it was incorrect, and that's what we can definitely gain from the record. Anything else would be pure speculation on counsel's part. The jury came back with a general verdict, and the court was free to inform and instruct the jury on the CCP aggravator because there was competent and substantial evidence to support that aggravator, and there was no error on the part
tell me if I'm remembering correctly, that part of the competent substantial evidence that was that the defendant had actually said that he pre-planned the murders.
Right. He went in there because he alleged that there was sexual abuse going on, and he switched weapons. He went in with a knife, and then he got a hammer. One of the kids was asleep. There was no danger to him. Clearly, the all elements of CCP were found in this case. The next issue was number 5, and counsel argues that the reasonable language should have been taken out of there. Again, the trial court used the standard jury instruction. There's no abuse of discretion by the court in this issue. In fact, as stated again by Justice Kennedy, they can present as many mitigation factors as they want, and the jury does not have to find them mitigating. They can find that they were proven, but not that they were mitigating. And as far as the reasonable qualifier, as the state argued down below, mitigation is subjective, and the reasonable qualifier doesn't suggest an emotional response other than reason. And she said it very eloquently. If one juror doesn't feel the fact that, for example, a defendant's father had a criminal history or that the mother was an alcoholic, maybe they don't reasonably feel that it is mitigating. And that's what happened here. I believe there were 44 mitigators, and they did not find that mitigating. And I believe if you look at the facts of the case, the fact that perhaps he was an alcoholic or used meth in comparison to the fact that he went into this home and slashed the throats of 2 young children and beat their skulls in with a hammer, perhaps they didn't find the lack of love or support from his family mitigating in this instance. As for claim 3, this was the victim impact evidence. And according to Florida Statute 921141, the victim evidence is designed to demonstrate the victim's uniqueness and the loss to the community and to the family. The grandmother testified during her victim impact statement, and it was a long one, and this was one sentence out of it. She talked about these kids, how much she loved them, and that the reason they were there was because of her. She lost her child in a car accident. The other one almost died. And that's when the decision was made for the family to move. So basically, every day of her life, she blames herself for the murder of these children, because they would not have been murdered, according to her, if they hadn't moved over there. And the reason they moved was because of that accident. So as the judge below determined, it was part and parcel of the whole story. It was relevant, and it was acceptable victim impact statements. And again, if you were to determine that it wasn't acceptable, it wasn't something that should have been included, there's no abuse of discretion, or there's no harmless error here, or there is harmless error. I don't see how you can take that phrase and say that that's why the jury came back with the death sentence. That's not why they came back. The facts of this case are so horrifying. That's why they came back with the death sentence. The medical examiner testified that Robert's neck had a sawing motion. That's where the knife wounds to his neck. The knife was inserted and twisted into his jaw. On Tayton, he had similar wounds, 11 to 12 slices. Again, a sawing motion with the knife. And he was conscious. He tried to get away. There was a defensive wounds, and there was a bloody handprint on the wall near the electrical outlet. That's why the jury came back with a death sentence, not because of a victim impact statement. The next issue was point 2 regarding the methamphetamine intoxication by the defendant. This was considered by the court, and based on all of the evidence, there was no finding that he was under the influence at the time of this murder. There was a police officer who testified to talking to the defendant that day. There's a video of it, of the interaction, and there's no indication that he was under the influence at the time. That morning, he went about his business. He went to a doctor's appointment, went to the store. The mother testified that she didn't see anything, that he was under the influence. She had seen him the night before while he was outside sharpening the knife in preparation for what he was going to do later that evening. The officers that arrested him and spoke with him, again, also no indication that he was under the influence. So the court did consider it, and they rejected it, properly rejected it. It is clear from this case that the defendant went in there with a pre-planned notion that he was going to kill these kids. CCP was properly introduced to the jury. It is clear from the record that he was not under the influence of drugs at the time. He was clear-minded enough to go in there and switch weapons to make sure the job was done, to leave a note behind, to gather up the evidence and hide it. It is clear from the record that the victim impact statement was properly given, and the reason that the jury came back with a death sentence was based on the facts of the case. And for that, the state would ask that you affirm the death sentences and convictions down below. Thank you.
Thank you, counsel.
In response, briefly, to the state's argument, in reply, as to point 5, there was no request there was no requirement, rather, to use the standard instruction. It's not mandatory that the court do that. And that's why it was requested below that that not be used. As it may encourage the majority to dismiss a holdout's concerns as unreasonable if they are arguably based in emotion, that is something that that is a reason for getting rid of that reasonable qualifier. It may lead the jurors to misunderstand how they're supposed to be treating their fellow jurors and what their reasons for not being all in sync with the vote. If they are arguably, and they should be able to keep their opinion, whether it's reasonable according to anyone else's opinion. If someone feels they have some concerns on the jury, they have the right, indeed, federally, to keep that opinion. And this particular argument, or this particular instruction, cuts against that. The U.S. Supreme Court requires, in the two cases I previously mentioned, in capital cases, each juror must be allowed to consider all mitigating evidence. And that's what didn't quite get done in this case, and we're asking the court to carefully consider that, which I know you'll do that, but to also send this back to the court for a new trial, at least a new penalty phase. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All rise. The Florida Supreme Court is now in session. Please be seated.
Okay, our third and final case for today is Williams versus State of Florida, 2023-1000. Counsel, whenever you're ready.
May it please the court, my name is George Burton. I'm here on behalf of Donald O. Williams. Mr. Williams is a Hearst resentencing, and this case is a wonderful opportunity for this court to strengthen the Sixth Amendment and make a double down on the importance of due process in this state. And the first 3 points on appeal are really interrelated. The first one, of course, is about a continuance. And as we all know, the black letter law, abuse of discretion, and all that, and very rarely are these issues ever given relief. Now, there are exceptions, and for example, in the days when any of you were involved in capital trial cases, if you got hit by a turnip truck the night before trial, they weren't going to go forward with the trial the next day, even if it was pending for 6 years, because it would be a violation of due process. Likewise, in this case, the analogy is this gentleman, despite his best efforts, could not get a mitigation specialist. And I have to say that one thing that did us a favor, Mr. Nunnally, who was a longtime Attorney General and now a prosecutor in Lake County, made a record as to why Mr. Williams did the extremely stupid thing of waiving a jury trial. I can't think of a dumber thing to do in a Hearst resentencing than waive your jury trial. But he did so because he wasn't prepared, as per his Sixth Amendment right, to make a case in mitigation because he had no mitigation assistance. And he did initially, and this is what I want the court to think about, because the case law against me is replete for the last 10 years. You guys have written great cases against me, and they're wrong because they're denying due process and full Sixth Amendment rights.
This is unpreserved, though, right, for starters?
Which aspect, sir?
The argument you're making about the continuance, was this preserved below? Was this preserved at trial?
Yeah, he made a motion to continue. It was denied. Yes, I believe so.
Okay.
I apologize if I got that wrong, but
no,
I don't believe.
He moves to continue. It's denied. And does he make any subsequent argument about this being a violation of his Sixth Amendment right?
With the prosecutor Nunnally, when he waived his jury trial, he made a record as to why this was so, much to the benefit of this case. And Mr. Williams explained that, he initially was at the Lake County Jail, had access to materials, was getting mitigation materials, but then he was sent back to UCI. Even though he was no longer under the sentence of death, he was treated as such. And as you may know, if you're there, your ability to present any kind of defense for yourself is extremely limited. The courts defer to the correction authorities for security and so forth.
But he knew about that when he chose to go pro se.
But that's not good enough, Justice Kennedy.
Well, but you're here to argue for him, but he's got agency. And
yes, he does.
And I know you think he's stupid, and he did some, or maybe you don't think he's stupid. You think he did some stupid things.
Yes, sir.
But he's got the right to do stupid things.
Yes, he does. But you can't say, well, if you want to assert your Sixth Amendment rights, by the way, you're screwed. You're not going to be able to present mitigation properly. You're not going to get your discovery properly because you don't have a DVD player like we had in this recent case of Sexton that you guys ruled. I mean, the case law against me is terrible. I'll admit that right here and now, but it's got to change.
But again, there are certain consequences that flow from self-representation. And it seems like to me what you're arguing is we should just waive all that off. And we should say the whole world has to be rearranged because he wants to, at least sometimes, to self-represent himself. And he had standby counsel. He could have gone with standby counsel for mitigation, right?
Yes.
He chose not to do that, right?
Yes, sir.
Why isn't he get the benefit of the choices he made?
Well, I'll tell you, when these bad decisions came ringing out, things have changed. There's more technology. It can be done. Where I'm not suggesting you give him an office at UCI with a view to prepare his case. I'm not suggesting that. If he was kept in Lake County Jail and just given the library and then allowed to have the mitigation experts, because if you see this record, this case went on for 6 years trying to get a mitigation specialist. 6 years. And the public is cynical of all the time it takes for these cases.
Yeah, but and I think it's, I'm glad you pointed to those 6 years, because I count the following: Brantley Investigations, Louise Godfrey, Sean Fisher, Dr. Sherry Schwartz, Casey Gallagher, Colleen Quinn, Jake Ross, Shotwell Investigations, Felicia Sullivan,
I don't mean to
Joanna
interrupt, Justice
Johnson.
Curiel, but
Just
they're
let me
not
get to
all
my question.
mitigation specialists.
Let me just
though.
get to my question. It sounds like it wasn't for lack of trying, and it wasn't for lack of options. Perhaps you would have a slightly more persuasive argument if there hadn't been, over the course of 6 intervening years, a number of people who Mr. Williams discharged said, "Get lost, I don't want you as my mitigation specialist."
The record's not so clear in that regard, sir.
Did I misrepresent?
There was substitutions for reasons we don't know. It's a cold record where we don't know. There was substitution of mitigation specialists, and then in the last one we had, she just disappeared under court order, and that was permitted. We don't know where she went. She met with him once, was gone. And they alerted the court, this is a problem. You may think back to the Barnes case, where Mr. Barnes wanted to do the same thing. What the judge did there was the judge found its own mitigation expert to do it, despite Mr. Barnes's wanting so, because you want to do individualized sentencing. Why can't we go back to those days? Why can't we do something like that, where you have true a de novo sentencing, which we didn't have in this case, which you guys also have no trouble with based on the Sexton decision. And so I know what I'm up against here, but here's a chance to start anew and fall in love with the Sixth Amendment and due process
but
again.
it doesn't, I mean, part of the problem here is this, like the record and the arguments being presented really aren't here. I mean, you're asking us to start anew without a predicate, really, for that. And you're saying the things about the mitigation that we don't really know. Well, you got to build a record. And I understand it's part of a problem when he chooses to do it himself. But to ask us to start anew on the basis of what we've got here, this doesn't seem like a propitious starting point for starting anew.
Well, if you believe, as the Founding Fathers did in the Sixth Amendment and due process, you would, because this is a sham. This is a sham proceeding. There's no other
Counsel,
way
if we were really starting anew, do you agree we would have to find a constitutional right for a mitigation specialist?
I don't think I don't think we've gotten there yet, but we should.
Okay.
And
where
ABA,
would we find that?
Pardon me, ma'am, I'm sorry.
Where would we find that?
No, I agree with you. There hasn't been an articulated constitutional right to a mitigation expert.
And where would we look in the Constitution to find that?
If you created this scheme, this statutory scheme under 921 with mitigation, it's statutorily created. You guys have to follow it. Well, how are you going to make it actually have any meaning? How are you going to do that? These are things that are very technical. They're not easy, and that's why this whole industry birthed, called mitigation specialists, which have to go through Tallahassee to be approved, and that was part of the problem here, is you have to for the JAC to pay for it, they have to be on the approved mitigation list, specialist list. And so since he was representing himself, there were a bunch of people who said, we don't do that. If he's representing himself. And see, the whole reason why he gave up a jury trial because he wasn't ready. And you know, that's part of the characterization of a sham proceeding. No jury trial, bench trial, with no mitigation developed.
The sham proceeding is a really, those are fighting words. What part of this is a sham exactly?
the fact that he was forced to give up his a jury trial to consider.
That's a very conspicuous use of the passive voice. Who forced him?
The inability to have mitigation that he
I'm
could
sorry.
prepare.
I'm looking for an answer to the question of who forced him.
Who forced him to do that?
You said he was forced to give up his right. Who forced him?
The judge.
The judge forced
The trial judge did by making this trial go forward without him having mitigation support.
Okay.
That is who. And like I said, they have a lot of discretion in these matters. And my initial example, getting hit by a turnip truck the night for trial.
Your argument is that the trial judge denied. Your argument is the trial judge forced him to jettison counsel and a mitigation specialist by denying this motion to continue after 6 years of proceedings to establish whether or not he could find.
You stated it perfectly.
I just think it's really, really dangerous to say that something is a sham trial when there's DNA evidence involved and when there's
we're not talking the guilt phase here, sir.
Okay.
We're talking about the penalty phase.
I'm not sure that's the word I would have chosen.
Oh, I understand, but it certainly gets your attention because that's exactly what it is.
It got my attention, all right.
Yeah, because that's exactly what it is.
That could be a good thing or a bad thing.
Pardon me?
That could be a good thing or not a good thing.
That's correct, but
I mean, there's a certain level of respect that is, I think, kind of normative.
Yes. Yes, sir. Absolutely. And I believe everybody who stands before you respects that and understands that. Absolutely. And I really believe that had this gentleman, though he decided to represent himself, if you had kept him just in the Lake County Jail with access to materials and access to a mitigation specialist, the first one had a stroke. That's how he lost the first one. We don't know why the other ones got subbed out, and we don't know why the last one disappeared. The record is cold on that. And it goes to my example of an attorney. I believe a mitigation specialist in a penalty phase resentencing is as important as having counsel. The case law doesn't support that statement, but in reality, that's a fact. That is the truth of the matter.
So, and you believe it's a due process right?
Yes, sir. Absolutely. And based on the decisions this court has made over the past 10 years, I'm swimming upstream, no question about it. But I challenge you to give it some thought as to how we can craft, because this is going to happen again and again. These defendants representing themselves, which is no one ever thinks that's a good idea. But it's going to happen again, and if you want to have it meaningful, and I go back to Barnes, where the judge appointed a mitigation specialist and did mitigation independent of Mr. Barnes, and this court adopted that, and that was a good idea. Well, we're not doing that anymore, and I think we should. And with that, I will let my learned Attorney General tell me how I'm wrong. Thank you.
Good morning. May it please the court, Doris Meacham on behalf of the state. The defendant knew what he was getting into when he decided to go pro se and when he decided to waive a jury and waive mitigation. Those choices were all done knowingly and voluntarily. In fact, one of the judges he had over the 6 years did not feel that he was not incompetent, but he out of an abundance of caution, wanted to have him observed to make sure he was competent. And this was after advising him over and over again, you need to get help. You can have counsel appointed, which he refused. You have standby counsel, you can help them, which he refused. So the judge had him evaluated, and he was. And according to that report, Dr. Maklis stated that the defendant knew very well what he was doing. And in fact, he said, if I lose this case, he would take solace in it because he lost it himself and nobody else did it. And that he knew the disadvantages and advantages of going pro se and the issues he was having with the mitigation specialist. So everything that he did was probably not the smartest decision, but it was a decision that he made on his own. No one forced him to do anything that he did. This was a grown man who made his own decisions to go forward. And as far as the motion for continuance, I would take some issue with it. I know it's argued as a motion for continuance for mitigation specialist, but in actuality, the motion to continue was for another evaluator. And this was basically another one of his tactics to get a continuance because he knew that he couldn't get another mitigation specialist. So that's why he put it in terms of another evaluator. In fact, the judge and the state attorney were confused as to that, and he made it clear that he was continuing it for an evaluator. But even if you
what can we tell from the record about why these mitigation specialists came and went? I mean, I understand there may be things we don't know, but what can we know?
On some of them, there were injuries. There was someone got sick. A lot of it we don't know. What we do know is that as of July 20, 2022, the mitigation specialist had been billed to JAC in the amount of $22,000. So I'm not sure what they had done or not done, or what the reasons were for not going forward and him switching so many times. But we can only guess that perhaps he made it difficult. I know that he wasn't the easiest to work with as far as standby counsel, so we don't know what the issues were between him and the mitigation specialist, other than every time he asked for one, he was granted one, and the judge bent over backwards to help him. And he was actually granted a continuance once based on the mitigation specialist, that she wouldn't be ready for trial. And so there was a continuance. So there is record support that there were mitigation specialists. He did meet with them. What was uncovered or not uncovered, we don't know. The defendant never says what mitigation was lacking. Because if you look at this, the trial court considered all of the mitigation from the prior trial, and in fact found an additional statutory mitigator and 2 additional non-statutory mitigators. So even if you were to find that there was an abuse of discretion, it was harmless. I mean, you cannot find any prejudice to the defendant in this case. This was a resentencing, and it had been done prior. He was actually pro se in the first trial, and then decided he wanted his counsel back because he saw it was difficult. So that part of the trial was actually developed by a trial counsel, and the state court considered all of it. So who would he have gotten? At this point, we could see that it wasn't going to happen. And in the factors that you look at for asking for continuance, it was foreseeable. I mean, he knew that he was not going to have one. He knew that he was having issues with it. He was reminded over and over again. I understand counsel's concern with the defendant's rights. He wants to proceed pro se. He wants to have a jury trial. Well, he also has to understand that there are pitfalls to that. And he accepted those pitfalls. And he was reminded every time he went into court of those pitfalls. And he had every opportunity to get help, and he chose not to. There's only so much a judge can do, and every judge that he had before him did everything they could to help him. The state went and bent over backwards as well and brought all of the discovery to him in court, and it was handed over to his investigator at the defendant's request. Everything.
To follow up a little bit on Justice Kennedy's question, isn't it true that the record does reflect that Investigator Fisher moved to withdraw from the case upon the defendant's request?
He requested, yes.
Okay, so it isn't just that, there was a stroke.
It isn't just that they just disappeared. And in fact, it got so much that, it seemed like every few months he wanted a new investigator, a new mitigation specialist, and he would just file these motions. And it got to the point where the judge was, you're not filing these motions anymore and asking for replacement. We're going to have a hearing on it, and we're going to hear from both sides, and we're going to know why they're being dismissed. So yes, it got to that point where it was like, we need to know what's going on. And yes, there is record evidence that he decided to dismiss the investigator and said that the investigator had completed everything he needed to do. And yet, a few months down the line, he requested another investigator. So yes, there is record evidence that it's not so much that the mitigation specialist didn't want to work with him, but he seemed to go through quite a few of them. Based on the record, based on the evidence in this case, we would ask that you affirm the lower court's death sentence. Judge did everything in their power to acquiesce to the defendant's requests, and even when they went forward without mitigation, she afforded him another opportunity to present mitigation, and he refused to. What we have here is a defendant who was stubborn and who was going to go down with the ship if he had to, based on his own decisions. And this was not a sham trial. He was given a trial and a penalty phase, and the judge took everything into consideration, and the conviction and the sentence should stand. Thank you.
Can I ask you a question, since counsel's kind of questioning the whole system? And I understand I'm not disputing people's right to put on mitigation and everything, but I'm just curious what you know, because we only see the cases where the mitigation didn't overcome the aggravation. I mean, how much difference do you think it makes when people don't get the death penalty in these cases? How much do you think, I mean, how often does the mitigation matter as opposed to just the, the jury and the judge's assessment of the, the severity of the crime itself, as opposed to the mitigation?
I think you could look at the last case we had where there was 44 mitigators, and the jury didn't find any of them. As far as the mitigation specialist itself, how important it is to the case, I'm not sure. You have the doctors, experts. The mitigation specialists really are just digging up facts from the childhood, from family, which the attorneys can do themselves as well. I believe that much of the mitigation that the defense could have presented, he could have presented himself on his own. It's his own background. It's his own childhood. He had evaluators before. He had doctors before. He wasn't even concerned with them. In fact, that was one of the issues that the judge brought up is, you've put everything, all your eggs in one basket on wanting a mitigation specialist, and you could care less about an evaluator and a doctor's testimony, which I think, as the judge was saying, is probably more important than the mitigation specialist, because they can come in there and say that he grew up in a bad neighborhood and his dad hit him or whatever it is. I don't think the mitigation specialist is as important as the information he can give to his own attorneys, or the information that a doctor or experts can get. And again, as I stated in the last case, where there was a mitigation specialist and there was 44 non-statutory mitigators, the jury didn't buy it. So I think a lot of it goes into what the facts of the case are, and not so much what a mitigation specialist can produce at trial.
Okay, thanks. Appreciate it.
Very briefly, sir. I think Justice Grosshans had an excellent question about the value of mitigation specialists and whether it's a constitutional requirement. And I asked this court to take this opportunity in this case to actually discuss that for the rest of the state, to give them guidance on how important, whether it's constitutionally required or not, or what have you, for mitigation specialists. This case is teed up for that, and I hope you'll take that opportunity. And thank you.
Seriously, what would you want us to say about that?
Adopt the ABA standards, that it's an essential part of a capital defense. That's what.
And then what? I mean, what consequence would that have?
An unwaivable part of a capital defense?
Pardon me, sir?
An unwaivable part of a capital defense?
Well, yes, it's unwaivable in the sense that and I go to Barnes. Barnes waived, but they still put it on anyway with an independent mitigation specialist appointed by the court. So it has to be a part of the recipe for due process because this is heightened due process, as you all recall, and they should get it in this case, due process and Sixth Amendment.
Sounds like it would just make a muddled area of the law even worse.
Well, reasonable minds can differ.
So you don't believe that the client's objective should determine the objective of the lawyer?
Traditionally, that was exactly the case. No, they weren't. The federal law, they're the captain of the ship, and they can do whatever the hell they want to do. But not here in Florida. You have individualized sentencing, and you can have mitigation put on whether they want it or not.
All right. Thanks
Thank
so
you
much.
very much.
We're adjourned for today. Thank you.
All rise. Merry Christmas.